Good afternoon, friends. Hope you all are doing well and taking great care of yourselves. It is pleasure to be connected with you all again in this second video. In this video, we are going to discuss another issue, and the issue is whether statement recorded under section 132 subsection 4 constitute incriminating material, or can addition be made solely on the basis of the said statement. We are aware that department conducts search operations. During the course of the search and the survey operations, statements are being recorded. The issue here is that can on the basis of the said statement alone addition be made? We are issuing notices, and it has been alleged that the purchases claimed by us are bogus or sales claimed by us are bogus because somebody in his statement has stated that he is just providing accommodation entries. Somebody has in his statement stated that he is providing bogus capital gain. So simply based on a standalone statement which is not backed by any other corroborative evidence, can a view be taken or can an addition be made, or can a view be taken against an assessee? Let us first deal with section 132 subsection 4. Section 132 deals with search and seizure. Subsection 4 authorizes the authorized officer, except the subsection 4 goes this way. The authorized officer may, during the course of the search or seizure, examine on oath any person who is found to be in possession or control of any books of accounts, documents, money, bullion, jewelry, or any other valuable article or thing, and any statement made by such person during such examination may thereafter be used in evidence in any proceedings under the Indian Income Tax Act 1922 or under this act. So if you look at the statement, they say that the authority is being given to the authorized officer to take the statement on oath. Now, such statement can be used as an evidence in any other proceedings as well. This is what is the impression is coming out from this. However, the courts have held that simply because of this statement, no addition can be made. It has to be backed by certain other corroborative evidence. So, alone a statement is not the basis for making an addition. Alone a statement under section 132 subsection 4 cannot say to have been constituted an incriminating material. So we are aware that in case of a search when the assessments are being reopened under section 153C or 153A, we always take a stand that before the date of the search, either the time limit to issue notice under section 143.2 was expired, where only 143.1 intimation has come, or we can say that the assessment under 143.3 has already been completed before the date of the search. Then those assessments cannot be disturbed without any incriminating material. So the question is, can standalone statement be the incriminating material? The answer is precisely no. And to support this view, we have so many judgments. Here is the list of the judgments which are now available on your screen. You can rely on those judgments. To name a few: CIT versus Harjeev Agrawal, Delhi High Court; Best Infrastructure India Private Limited, once again Delhi High Court; Kailash Ben Choksi, Honorable Gujarat High Court, right? And the recent one where so many judgments have been referred and a view has been taken is that of Nilesh M. Agrawal, reported in Text Sutra 716 IT80 2022, Mumbai. It's August 2022 judgment where the view has been taken that alone a statement cannot be the basis for the purpose of making an assessment. What does the court say, or what is the ratio that is coming out or emerging out of all those decisions is the undisclosed income of an assessee has to be computed on the basis of evidence and material found during search. The statement recorded under section 132 subsection 4 may also be used for making the assessment, but only to the extent it is relatable to the incriminating evidence material unearthed or found during search. In other words, there must be a nexus between the statement recorded and evidence slash material found during search in order to form an assessment to be based on statement recorded. So it is very clear that unless otherwise there is a corroborative evidence available, no addition can be made on the basis of only a statement recorded under section 132 subsection 4. The statement certainly has the evidentiary value and relevance as contemplated under explanation to section 132.4. However, this statement cannot on a standalone basis without reference to any other material discovered during the search and seizure operation empower the AO to frame the block assessment. So this makes it absolutely clear that simply based on a statement of a third party, no addition can be made. Here I would advise my viewers that whenever you come across a notice where an allegation is there upon us that we have entered into certain transactions and they are based on those statement of, recorded under 132.4, please demand the copy of the statement recorded, and please also demand the copy of statement, and please also demand the opportunity to cross-examine the concerned person making the statement as well. Please note that it is the duty on the part of the AO to provide that, and please also note that once we have demanded those documents, AO has to provide, and if AO does not provide, we have series of judgment of Honorable Supreme Court in the case of Andaman Timber and so many other judgments where a view has been taken that if the cross-examination opportunity is not provided, then the assessment made in the case of an assessee making addition or disallowances would be bad in law. Now, is there a department circular or a clarification on that? The answer is yes. Let me share with you an instruction number 20/2015 dated 29th December 2015. Here, through this instruction, the board has made it absolutely clear that the statement needs to be provided and importance of the principle of natural justice has been emphasized in this letter. Let's read the para 4. The board further desires that all cases under scrutiny where the assessing officer proposes to make addition or disallowance, all cases under scrutiny where the assessing officer proposes to make the variations, the assessee would be given a fair opportunity to explain his position on the proposed addition disallowance in accordance with the principle of natural justice. Now this is most important. They say that the assessee should be given all the opportunities, all the opportunity to explain his position and in accordance with the principle of natural justice, meaning thereby cross-examination has to be offered, meaning thereby the statement recorded on which department is relying upon as mandatorily required to be offered, and if you have demanded and has not provided, in that case it becomes a strong case. Moreover, let us read further. What does it say? In this regard, the assessing officer shall issue an appropriate show cause notice duly indicating the reasons for the proposed addition disallowance along with the necessary evidence reasons forming the basis of the same. Meaning thereby the statement, even if I have not demanded, assessing authority has to provide the same along with the show cause notice. So let us take a case that we have forgotten to demand it. Still we can rely on this circular saying that, let us say I have not demanded the circular, I forgot to demand, but then it should have been your duty to provide that particular statement along with the show cause notice because it has been categorically provided in an instruction number 20/2015. Sometimes we also see that I have made a statement that I have got an undisclosed income of so and so amount. Simply based on that statement and no, without any kind of any other evidences, an addition is being made. Now, can the addition be made in my own case simply based on a statement? Once again, here the CBDT has come up with a letter dated 18th December 2014 where the practice of making additions precisely based on the statement recorded is to be demotivated and emphasis is given to find out the evidences. Let's see what does the letter talk about. Instances complaints of undue influence coercion have come to the notice of the CBDT that some assessors were coerced to admit undisclosed income during search survey conducted by the department. It is also seen that many such admissions are retracted in the subsequent proceedings since the same are not backed by credible evidence. Such actions defeat the very purpose of search survey operations as they fail to bring undisclosed income to tax in a sustainable manner, leave alone levy of penalty or launching of prosecution. Further, such actions show the department as a whole and officers concerned in poor light. The board has emphasized upon the need to focus on gathering evidence during the search survey and to strictly avoid obtaining admission of undisclosed income under coercion under influence. So indirectly, this letter also says that precisely based on a letter or precisely based on an admission which is not backed by any other evidences, no addition should be made precisely based on such kind of a letter. Now, the last issue for this video is, can a statement recorded under survey be the basis for making an addition? First we discussed, can a statement recorded under 132(4) be the basis for addition? Now we are talking about survey. Once again, we have direct Supreme Court ruling available in this case. In the case of S. Khader Khan's son, 2012, 25taxman.com 413 Supreme Court. What they have said? They have said that statement on oath made by an assessee to income tax authority during the survey proceedings under section 133A is not coercive and is not conclusive. I'm extremely sorry. Statement on oath made by an assessee to income tax authority during survey proceedings under section 133A is not conclusive, and assessee can explain or withdraw the admissions, if any, made by him. In such statement, an assessment of tax cannot be made solely on the basis of such sworn statement made by assessee under section 133A subsection 3 clause 4, and such statement can be used to corroborate other material found before assessing authority, including the content of any document. So this makes the thing very clear that simply based on a statement, no addition can be made. So with this discussion, I am concluding this video. If you have any doubts, queries, please feel free to raise the same in the comment box. It would always be a pleasure addressing to the same. If you want me to prepare a video on any other topic of your area of choice and concerns, please also do share the same. I'll try to do that as well. Thank you very much, and please take good care of yourself. Stay safe, stay blessed.